So this is a procurement and state aid update. Thank you for taking part. Sorry, just gone back rather too far. So yes, 2020. What a year it's been. It's kind of quite hard to say how you can summarise it really, but well, let's say it's been difficult. In terms of things that I'm going to talk about, I would have liked to have talked about the new regime in terms of state aid and public procurement. Unfortunately, as we all know, Brexit negotiations haven't yet been completed. So in reality, there's a lack of clarity on that front. What we do know is the Public Contracts Regulations 2015 are going to stay in place with some minor amendments. State aid is not too certain. What I'm going to touch on, and what I think is relevant to what we're talking about today, is COVID-19, the effect that that's had on procurement and guidance that we've had, some sort of guesstimate in terms of where we are on Brexit, looking at some quite interesting bits of case law and dealing with some of the issues that we have seen as a result of Brexit. So, procurement issues, what have we seen? Well, we've seen a very widespread use of certain purchasing policy notes, particularly purchasing policy note 01/20 and 02/20, related to responding to COVID-19. I think what's been quite difficult for all of us is that purchasing policy notes have been treated as if they are law, and they're not. They, for example, encourage local authorities, public sector bodies to be very generous towards contractors, for example, not to insist on compliance with key performance indicators, perhaps to pay invoices before they would normally due, and to really keep suppliers afloat, which isn't really any scope of procurement law, that's government policy. And a number of suppliers have said to our local authority clients, you should be following this because it's in the guidance. The answer to that is no, it's guidance, it doesn't have force of law. And I think, a number of authorities are finding that their resources to be able to bail out suppliers are becoming limited now we're, 9 months into the period of time since lockdown started. In terms of ways in which things can be procured rather more quickly than is typically the case, I want to look at two particular provisions. The first one is what's called the general urgency provisions. An example, this is within the open procedure, it's regulation 27.5. Obviously, normally the period of time between publishing a contract notice and making a decision is based on a 35-day period. Under 27.5, and there are similar provisions with the other procedures, where a state of urgency duly substantiated by the contracting authority renders impracticable that time limit. It may fix a time limit, it being the authority, which shall be not less than 15 days from the date on which the contract notice is sent. So basically, as long as you can show a degree of urgency, you can contract based on a 15-day period, which I think is helpful. The other thing that we have is extreme urgency. So we've got two levels of urgency, ordinary urgency and extreme urgency. That's set down within regulation 32, and that's the one I think that has been more generally relied upon. That allows, of course, to remind those who don't know, to use the negotiated procedure, so you can negotiate a contract without any prior publication of an advert whatsoever. However, the requirement to qualify under regulation 32(2)(c) states that can be used only insofar as is strictly necessary, where, for reasons of extreme urgency brought about by events unforeseeable by the contracting authority, the time limits for open or restricted procedures or competitive procedures with negotiation cannot be complied with. So actually that's imposing quite a high standard. The government policy guidance says, well, COVID-19 is serious, risk to life, designed to deal with this sort of situation. But what I would stress is breaking down what I just read to you in terms of some bullet points. There need to be genuine reasons for that extreme urgency. The events leading to that extreme urgency need to be unforeseeable. it's impossible to comply with the timescales set out within the public contracts regulations, even if you're using the accelerator, that's 15-day procedure. And the situation isn't attributable to the contracting authority. I'm afraid we have had some situations where the contracting authority, frankly, has been quite slow in sorting out procurement. And they said, oh, can we say it's extreme urgency because we spent the last month not issuing the contract notice that we should have done, and that isn't really acceptable. So I'm afraid it can be abused. Something else I think to bear in mind, and this is touched on within the purchasing policy note guidance, is that, of course, as an alternative to letting a new contract, you might continue with an old contract for a period of time or increase the scale of that contract. Regulation 72 of the Public Contracts Regulations 2015 do allow you, and there are some caveats on this, which I can speak about separately if you want to contact me, is that you can increase the overall value of a contract or the duration of the life of that contract by up to 50% for pre-existing contracts. So it may be, for example, you have a 3-year contract, well, maybe just extend it for a year. That makes sense. Question that I think one has to ask is, where does this leave value for money? We've heard all sorts of stories about people paying over the odds for equipment, for example. What I would say, and those of us who are advising authorities, just because you can contract via extreme urgency without a contract notice doesn't mean that you ignore value for money altogether. There are overriding duties, Regulation 18, for example, the public contracts regulations that say, there's still a general obligation in all situations of authorities to seek to ensure value for money, competition, level playing field, and all those basic procurement principles. So do bear that in mind. And I'm afraid that there's been perhaps a little bit of abuse on that. Also, I think we have to say, if there's something of a risk in that the whole process of public procurement is falling into disrepute, it's something where, quite rightly, I think in the UK, we followed some quite scrupulous standards about following the rules properly, and they apply for every public sector body in the land, whether it's down to a school or a parish council or a large national government department. And it does seem rather like the fish, as it were, rotting from the head. We're seeing a very poor example, I have to say, quoted to us by central government. Just one example, here's a quote. I'm sure there were lots of others from Private Eye. How the government gave a multi-million-pounds contract to a Tory donors firm based on a telephone call with the NHS, with no written record to show who recommended the firm or who agreed the deal. And we're seeing more and more stories like this. We understand that there is some litigation bubbling underneath there, the government are paying money to get rid of tenderers. But of course, unless you can very genuinely show that Regulation 32 applies, giving major contracts without following any sort of proper competitive, scrupulous process, which of course avoid suggestions of collusion and corruption, is very, very important. And I think eventually there may be a reckoning in terms of these things. What else is happening? Well, of course, the big news, and I did have a query about this before the event, is that we're saying goodbye to OJU from the 30th of December, come what may. OJU, so contract notices going into OJU, which is of course the official journal of the European Union, we are going to cease to be able to use that. Instead, what we have is find a tender, which might mean that we have to get used to calling things FAT notices, which doesn't sound very complimentary. There's not an awful lot of information about how find a tender is going to work. It's going to go live at 11 p.m. on the 31st of December. There is some limited guidance about it to be found on a purchasing policy note which was issued last week. That's PPN 08/20. Organisations will need to register with it, including suppliers. So there's a supplier registration page and there's a buyer account page. Some of the large tender portals are already signed up with it. If you are an organisation, you need to register involving what's called a DUNS number, which is, I think, a Dun and Bradstreet number to prove you are who you are. Organisations that are currently within procurement processes, those processes could carry on. So, as it were, something that's following an OJU notice that was issued in October or something, when contract award happens in January, when the contract award notice will go within ODU rather than within final tender. But otherwise, in terms of all new procurements, as from the end of business on the 31st of December, you are supposed to be using this new system. If you go to gov.uk, look under public procurement, there's a link to the find a tender guidance, which I say is very, very limited at the moment. And I would have liked to have shown a mock-up of how a website's going to work, but at the moment access to it seems to be limited. The other thing that I think people have been asking, and asking frankly since 2016 when the referendum took place, is what potential regime changes are we going to see in terms of procurement? Short term, obviously, the regulations continue in effect, albeit the financial thresholds are based on a pound number rather than a euro conversion arrangement. But otherwise, business as usual. What I think we are seeing, and there has been a lot of talk about, is that the 4-year time limit for frameworks is regarded as restrictive, and that may change. It's interesting that even Crown Commercial Services within their own frameworks are having 6-year durations, which is possibly quite dubious under the scope of the current law. Something we're also seeing is more widespread use of frameworks, but frameworks which are led by the private sector. Now, to run a procurement framework, you need to be a contracting authority. It seems that there are a number of private sector organisations who are finding a friendly host authority, and the system is working in that way. But I think we may see further changes going forward. Just to touch on some interesting cases, there have been some very interesting and relevant cases over the last few months, and they continue come what may. Obviously, at the moment, we can utilise cases decided across Europe. What's going to be interesting going forward is we're going to be in a situation where we're not going to be subject in theory to a European jurisdiction, but the law on procurement is going to be pretty much the same between the UK and Europe. So I think these cases will continue to have at least persuasive, if not sort of binding effect when they're dealt with domestically. The case of Remondis is an interesting one. This is on the public cooperation, what's called the Hamburg Doctrine, which is now, I think, within Regulation 12 of the public contracts regulations, which means that when public sector bodies are working one with another, if that is part of a cooperation that's in the public interest, then the procurement rules don't have to be followed. You can simply award a contract, for example, to another local authority, providing you with a service. Now, this was challenged in Remondis. Remondis was a supplier, I think, concerning waste services in Germany, about waste management, and I think Koblenz, I think the town in Germany, was contracting with another local authority, or I think more rightly, an organisation jointly controlled by several local authorities for dealing with processing of waste. It seems that joint company, once it had the waste, it didn't have its own treatment plant, so it actually outsourced waste processing either to another local authority, or for the waste that couldn't be disposed of through that processing plant, it went to a third-party private organisation. Now, Remondis said this is a sham. It's not really public cooperation. It's one local authority awarding another contract to another without going through any sort of procurement process, and also somebody that couldn't really carry out the role anyway. I'm sure that was one of their competitors. Now, actually, the court, I think, in quite a generous decision, ruled in favour of Remondis, but said the court does not require a specific form to be taken by cooperation between public authorities, nor does it confine the activities related to the performance services and responsibilities assigned to or assumed by the participating authorities that form the object of such cooperation. So what they said is, you can have a public cooperation, but it needs to work properly, and needs to be analysed quite fully. In this case, on the facts, maybe there is an issue, but possibly not otherwise. A similar case is that of Stat Coal, which goes back to 2018, but was only properly heard through in 2020. That related to Cologne acting as an organisation that in effect was running software on behalf of a range of local authorities. And here I think it was the Berlin local authority, all the cases seem to be in Germany, that were in effect operating software that was originally created by Land Berlin for operating public fire services. Now, again, the organisation involved was subject to a challenge from somebody called ISE, who are a software company. They said that Cologne had awarded a public supply contract within the public procurement rules, shouldn't be allowed to carry on. In that case, very similar in some ways to Remondis, it was stated that cooperation between contracting authorities does not have to relate to the actual public services themselves. It can be supporting activities. So incidental services are fine. The cooperation was permitted, was allowed, the contract was ruled to be lawful, but it was stated that cooperation between contracting authorities must not have the effect, in accordance with the principle of equal treatment, of placing a private company in a privileged position in relation to its competitors. So what can we say from these cases? Well, the answer seems to be that the courts will, in appropriate cases, be generous, but there needs to be a public cooperation. It's not just a sort of free reign in terms of one local authority being able to work contracts with the local authorities. There has to be some sort of cooperation, and there has to be some sort of public service purpose that's there. So do look at that quite carefully. Ryhurst. I think Ryhurst is a very interesting and topical case related to abandonment. A question that we frequently get from private sector and public sector alike is, we don't want to go ahead with this procurement for whatever reason. The bidders have spent an awful lot of time and money in putting their bids together. Sometimes somebody's even been appointed as the preferred provider. Do we have an obligation towards contractors or tenderers if we decide for whatever reason just not to go ahead with the procurement and abandon it? There's a case called APCOA against Westminster going back to 2010, where Westminster local authority didn't go ahead with a project related to on-street parking management with APCOA. We may have come across a parking management company. And the basic principle from that case has been that actually local authorities have a free decision. Even award a preferred bidder is still subject to contract. A recent case last year in Sussex said that there may be circumstances in which that doctrine doesn't apply, but that was really in a very narrow circumstance where a procurement is abandoned because of a procurement challenge, and it seems to be a way to get rid of a challenge. The Ryhurst case. This is related to the Ryden Group. That may ring a bell. Ryden and Ryhurst have been involved in a number of projects, particularly for the NHS, but also Ryhurst Limited, who were the company involved here, are part of a group involving Ryden. Ryden Maintenance were responsible for the refurbishment and supply of insulation and cladding, of course, at Grenfell Tower. Now, in this circumstance, even though it was a very different company, albeit part of the same group, there was a strong public campaign, including heavy support from local MPs Jeremy Corbyn and Emily Thornberry, not for the local NHS trust to go ahead with their procurement because of the organisation that was involved. And it was claimed that the decision that was taken, now apparently the procurement started in 2016, but the decision to abandon wasn't taken until as late as 2018. The trust said, we're going to abandon the procurement, we're not going to go ahead with it. Now, the NHS Trust said the reason to abandon the procurement was lawful and was taken for a number of proper reasons. Talked about things like risk that stakeholders wouldn't engage in support plans. The argument by Ryhurst is that it was unlawful, it was a political reason, nothing to do with procurement. That was looked at in some detail. Basically, the court stood by the public sector body in this case. It pointed out that the trust had argued that there was a change in its financial position compared to 2016, And that was the principal reason that the Trust Board decided in 2018 to abandon the procurement, and that the Trust was entitled to take into account a lack of stakeholder support in terms of its decision to abandon the procurement, bearing in mind that if stakeholders won't take part, then there's difficulty in going ahead with the procurement. And it was stated by the opinion of the High Court judge, it was in no way irrational or improper, and the Trust Board did not act improperly in deciding to abandon the procurement, looking not just at the present, but also to the future. So I think what that's saying, it's protecting the basic principle that a public sector body does have a discretion to abandon a procurement for whatever reason, be that economic, be political, or even in this case, because there are issues about the identity of the provider involved. But I think providers will keep challenging these situations. But I think that does protect the position. What I would say is that most tender documents do, of course, contain wording to the effect of the public sector body may decide to abandon the procurement, to not go ahead with the procurement, not to award a contract to anybody, and if it does, it's within its rights in doing so. But I think it's a good second line of defence to have that wording within your tender documentation, if you don't already. A case related to challenge, and we're always seeing challenges, is Neology against Newcastle City Council. This was a case related to automatic number plate recognition systems, which obviously is increasingly relevant. In this case, it was because Tyneside were introducing a clean air zone, and of course you need to know number plate identification to detect vehicles with high pollution or people that are not paying their charges in terms of going into various zones, rather as it is with the congestion zone in London. Now, in this case, Neology were a tenderer. They were third after Siemens and Systems Engineering. They said it was unfair. It's a well-argued case, and the sort of arguments that were involved is that there were sort of improper processes involved in terms of the decision that was made, and the ability of a local authority to exercise discretion in terms of going forward. The application was for summary judgment against the councils because they didn't follow a proper process. I think that there are the facts, but I think the legal principles are relevant across the board. Neology, in the opinion of the Technology and Construction Court, comes nowhere near administering the knockout blow to the defence necessary to obtain summary judgment. There is no obvious unfairness or manifest disparity of treatment between tenderers. They just looked at the nature of the procurement, the evaluation criteria, the weighting, and the scores awarded, and there is no obvious flaw within that. Of course, they were after a summary judgment. The case might go on in terms of damages, but probably didn't. So I think what the argument is that if people are challenging, even if there are minor problems within your procurement, and there sometimes are minor issues or arguments here and there has to be very clear evidence that the public sector body has done something wrong in order to win. So, arguments that the questions seem to be unfair, that there's some perceived unfairness in terms of the procurement process that's carried on. Well, this repeats the general principle, which goes back to a number of cases, Hammersmith and Fulham case a few years ago, that really the challenger needs to find some sort of manifest problem within the treatment between bidders for there to be an argument in terms of liability. It strikes me that this was a bit of a spurious case at best, really. And rail franchising, perhaps not of direct relevance to a lot of people in this discussion, but I think some of the principles involved are very, very interesting. As you might be aware, there's been a lot of controversy about franchising of contracts in connection with, beg your pardon, there seem to be, yeah. Yeah, there's a lot of controversy about the way in which rail contracts have been awarded. These are clearly big money contracts. So, consortium involved were unhappy about the decision made in terms of procurement. In particular here, the Department of Transport, SST is Secretary of State for Transport, disqualifying Stagecoach. The argument was that this was unlawful in terms of what was done. Now, the main reason for disqualification was related to the pension scenario. Generally speaking, there was a requirement to take full pension risk on board to be a qualified tenderer. Stagecoach took the view that the potential liabilities in terms of taking on pension responsibilities for the employees concerned, obviously inheriting the old railways pension scheme, was so large that this was really an external risk. It's what they called an exogenous risk, a risk that went beyond the scope of the contract. And they said, therefore, it was unfair to be disqualified because they would not take on an uncertain and enormous risk. They proposed an alternative risk allocation. The case doesn't detail quite what that was. The court said the allocation of pensions risk did not breach the principles of proportionality and fairness. So basically, the Secretary of State for Transport was entirely within its rights in deciding that somebody that wouldn't take on board the risk profile that was inherent in the tender was quite within its rights in saying if you can't meet that risk profile, then you are disqualified. The other argument that was raised was that there was some sort of undisclosed evaluation process, some undisclosed criteria that was going on. Something that I have seen here, many of you will have seen it, is that there was a log kept during the evaluation process. That log indicated where there were non-compliances by tenderers, and it rated those non-compliances on a scale of 1 to 5. Stagecoach claimed that the use of that log was an undisclosed policy for evaluation of bids. So in other words, as well as the ordinary scoring, this logging arrangement was a separate sort of secret scoring arrangement. The court said this log was an administrative tool used for prioritizing internal resources and played no part in determining evaluation. So the fact that there was a non-compliance log and that would be checked as part of the evaluation or prior to evaluation was absolutely fine. So basically, the court said that the Secretary of State for Transport was entirely within its rights in exercising its discretion to reject a tender for non-compliance. Obviously, this was an expensive and non-running tender, and people will have a go. But I think it reinforces the message. Sometimes when we are advising authorities, they do feel quite nervous about disqualifying bidders because they're going to feel quite sore about it. Well, this says you can disqualify bidders if they don't meet the core criteria. Social value. There is increasingly a talk about social value and the sort of havoc that's being wreaked on the social fabric at the moment by lockdown can't be surprising. We've had some questions about the status of social value in contracts and to what degree you can take that into account, superimpose on the traditional criteria within the public contracts regulations, which is, of course, looking at the most economically advantageous tender. The purchasing policy in that 0620, I think, is quite interesting and worth a read. It's slightly contradictory in that it says under paragraph 2 that social value should be explicitly evaluated in all central government procurement, where the requirements are related and proportionate to the subject matter of the contract, rather than just considered as currently required under the Public Services Social Value Act 2012. But it then goes on to say that this procurement policy note applies to all procurements covered by the Public Contracts Regulations 2015. So although it seems at one point to say it's about central government, local government have seen this and it's a bit vague in terms of whether to some degree it has an effect on local government as well. So I think it's worth looking at, and I think taking account of social value is typically more and more important for authorities. And I think there's no problem in taking it into account and referring to it as part of a tender process. And some of the key themes and outcomes that it suggests that authorities have to look at in terms of evaluation is COVID-19 recovery, so how are tenders helping communities recover from COVID-19, how economic inequality is being looked at, so that includes creation of new businesses, creating new jobs, creating new skills, increasing supply chain resilience, tackling climate change or environmental issues, equal opportunity, particularly in things like disability, employment, and other workforce inequalities, improving health and well-being, and improving community integration. So I think, when you're putting tender documents together, it may be worth saying that you're going to look at that. A lot of authorities now do seek to take that sort of thing into account. And also, it mentions having the ability of providers to access online learning to develop is something that might be appropriate. So something quite interesting. So what else is going to change after the 1st of January? I mean, I think it's the elephant in the room, and Brexit has kind of been put to one side with all the COVID-19 issues. Well, one thing is, of course, at the moment, we are used to having supervision to some degree by UK government, but also ultimately by the European Commission. And there have been some authorities that have been taken to task for not following the rules properly, and that's gone up to a European level. Well, now, as I understand it, it's going to be the Competition and Markets Authority. Will they exercise more close involvement in procurement decisions? Nobody knows. What about a Buy British policy? The public contracts regulations are obviously based on a European directive and based on not having geographical discrimination, which would be pro or anti, say, British companies. But one could see a situation where that's going to pull down a bit, and increasingly, are you going to see people looking at Buy British policies? I think you have to be careful about being explicit about that, because, of course, we're also going to have some sort of accountability into Europe. Nobody quite knows how that's going to work, but I think if we are saying that we are going to follow these regulations and ensure free trade, being too restrictive can be a difficulty. What about tariffs? A number of long-term contracts, supply contracts, framework arrangements are based on pre-agreed prices. You think of things like the construction sector, for example. Well, if a free trade deal is not agreed, then a lot of materials imported into the UK are going to be subject to tariffs. I think some of us have seen the very high numbers about things like agricultural products, which are unlikely to affect local authorities so much, but certainly regular tariffs of things like manufactured goods, vehicles, for example. There will be a 10% tariff on the imported vehicles. If you are purchasing, say, vans for use by your authority, well, how is that going to affect the pricing? Even parts and metal goods are going to be subject to the same sort of restrictions. So how is the pricing going to work? You have tightly agreed prices. Our tenderer is going to come to you and say, well, we need to increase our prices by 10%. If we enter into contracts, perhaps you need to allow for contract variations where they're strictly caused by the imposition of tariffs that we're not aware of. What about WTO? For a lot of talk about WTO terms, the UK is or will be within the World Trade Organization, and there's something called the Government Purchasing Agreement that is part of those WTO terms, or part of a treaty that was agreed in Marrakesh in the 1990s. What that does mean is that the UK government, like all governments within the World Trade Organization, are committed to having government procurement which is fair and transparent. So just because we might be out on a no-deal basis doesn't mean that the UK government doesn't have treaty organisations to follow a fair and transparent process in terms of government procurement. And if, for example, you have an only buy British policy, then that would tend to fall foul of that. So I think it needs to be looked at quite carefully. As I said a few minutes ago, there is, I'm afraid, a lack of any real clarity, but there is potential to perhaps raise thresholds, obviously be too low, and to lengthen the framework durations. A few minutes on state aid. So about the future. I think there's an interesting distinction here in that where we have UK procurement regulations, state aid, as people might be aware, are very much based on Article 107 on the Treaty of the Functioning of the European Union. We're told that state aid is something that is a bit of a sticker in terms of discussions between Michel Barnier and the UK team led by David Frost. So what's going to happen there? What crystal ball gazing can we do? Well, firstly, I think I have to say, is the regime broken? Since COVID, of course, we've seen vast amounts of money coming in from the public purse to help all sorts of organisations, small and large. Local authorities are, of course, involved with local issues, for example, supporting local industry, rates relief, and that sort of thing. And of course, many organisations are getting grants, bounce back loans, furlough payments, etc., etc. So the whole concept of state aid as being something which is wrong has really, I think, gone out the window. That, I think, in some ways discredits the regime. We are seeing an increased use of the block exemptions within GBER and other exemptions, a willingness to perhaps support and to look creatively at exemptions. For example, if the support given part of local infrastructure under, I think, Article 56, support being given for cultural facilities. There's also the interesting argument that if aid being given is incapable of affecting trade between member states, then it's probably okay. So as an island nation, things that happen in the UK are probably less likely to relate to people across Europe. So if you're funding a local facility, it's probably quite unlikely somebody's going to pop over from Italy for the day to use your local swimming pool or something like that. So I think there's an increased willingness to look at exemptions quite creatively. COVID-19 has, of course, led to widespread approvals, particular schemes, and they're going through Brussels actually quite quickly. And there is, as many of you will know, the general ability to give de minimis aid related to liquidity support of up to €800,000 per organisation. So historically, you're allowed to give aid of up to €200,000 over a period to bodies without it qualifying as lawful state aid. Now, if it's to do with COVID, that level is 800,000. My understanding is you can have a general 200,000 de minimis exemption with €800,000, so effectively have a potentially €1 million exemption before you even have to look in terms of detail at other exemptions related to state aid. There have, of course, been massive bailouts of organisations around Europe, Air France, Lufthansa, etc., which have been approved very quickly on the nod by the EU because of the emergency. And there are many schemes, such as the bounce back loans, approved by the EU. So, slightly cynically, does anyone really care anymore? There is so much state aid going on. The regime is not as important as it was. Will unlawful state aid still exist post-Brexit? I think, yes, it will. But of course, there won't be approval for schemes from Brussels, as far as we know, although there may be something in that line. Will there be continued scrutiny by the European courts? The UK government is trying to resist that. Who knows? There are some reported sticking points. The government, as part of its levelling up agenda, dealing with red wall seats, etc., would like more freedom to support technical innovation and investment. And even technical support at the moment can fall foul of being unlawful state aid, and that's reinforced by government departments. Even if we are just on WTO terms, there are still all sorts of World Trade Organization obligations about not discriminating against suppliers, about transparency, and about anti-dumping in terms of goods. Well, doing some research on this, as I said, David Frost is the UK negotiator, and he's been communicating with the Brexit Select Committee and stated quite recently these are the agreed principles that he's working to. That's agreed with the government, not necessarily agreed with the EU, that he would like a broader, more generous regime in terms of state aid, with less specific and detailed rules, unlike the 50-odd individual exemptions within GBR, to something far more principle-based and more global. For example, state aid should be justified on public policy grounds, such as market failure. It should be proportionate and not excessive. No one wants to go back to the bad old days of bailing out British Leyland. It should be open and transparent. It should be aimed at leveraging changes in business behaviour. For example, support to electrification of transport fleets, something that we've looked at and is still not entirely straightforward in state aid terms. and it should be part of a government policy purpose, but it should be avoided in general if there are negative effects on trade and investment. So if you're favouring one organisation over another and hurting other organisations, that's something that you don't want to do, and state aid shouldn't distort the market too much. But it should encourage good policies, for example, green activity, helping deprived areas. Some of this is already allowed for under some of the exemptions within state aid, but it's a minefield finding the way through it. I think the idea is that there should be some more broad general principles and not the same detailed regulatory exemption provisions which keep lawyers so busy at the moment in terms of advising on state aid issues. And hopefully that will lead to a simpler regime, which I think will help all of us, other than possibly lawyers who won't be able to bill quite so much for charging on state aid advice. Finally,